Going to start now. Today is a 252nd Friday group meeting. The topic is Fundamental Principles of Law and Logic. The speaker is Ms. Tadepalli Varalakshmi, advocate from Hyderabad. She came all the way from Hyderabad. In fact, Attorney General Office introduced me. In fact, that's before Varalakshmi starts, I request Niharika will say a few words about Niharika, please.
Good afternoon, everyone. Thank you for being here today. It is my honor to introduce today's distinguished speaker, Ms. Varalakshmi Tadepalli ma'am. Varalakshmi ma'am is a seasoned legal practitioner with 27 plus years of expertise in real estate, infrastructure and commercial law, and also serves as founder and principal counselor at India Legal Advocates as of now. She has advised prominent clients on investment structuring, regulatory compliance, and commercial documentation for complex real estate. Known for her strategic use of statutory frameworks and interdisciplinary insights, she combines legal precision, business acumen, and client focused advice. She had notable past roles as resident partner at Dua Associates and had a strategic partnership with Tatva Legal Hyderabad as well. Ma'am also holds advanced degrees including Masters in Law from Jindal Global Law School and Masters in English Literature from Peria University. Following her undergrad from Osmania University, she also holds PG diplomas in Human Rights from University of Hyderabad and Media Laws from Nalsa University of Law. Ma'am is a contributory speaker at national workshops and legal forums, sharing her expertise on topics such as contract law, capital gains in development agreements, consumer protection, and real estate compliance. Ma'am has been invited in different talks like at the National Workshop on Protection of Trademark in Consumers' Interest in 2023, at LEAP, that is Legal Education and Awareness Program in 2020, thirdly at Legal Workshop on Legal Due Diligence from a Realtor Perspective in 2016, and at the Masterclass on Commercial Contract Negotiation Dispute in Arbitration 2016, speaking on breach and termination of contract in 2016. Ma'am has also participated in national workshop on real estate laws discussing incidents of capital gains on development agreements in 2010. With nearly 30 years of experience, Ma'am views law as a disciplined pursuit of integrity, strategy, and service. Her practice blends expertise in statutory frameworks with a keen understanding of commercial realities, offering tailored legal solutions while remaining committed to legal excellence and lifelong learning. Please, all of you, join me to welcome Ma'am. Welcome, Ma'am.
Am I audible, sir? Good afternoon, respected members of the Friday Study Circle. I am honored to be
Friday group, madam.
Friday group. I am honored to be addressing the gathering esteemed advocates today. I want to start by expressing my heartfelt thanks, gratitude, and organizers for inviting me to share my thoughts with you all. I am humbled by the opportunity to interact with such distinguished group of legal minds. The Friday Study Group is renowned for its thought-provoking discussion and debates, and I am thrilled to be part of it today. I look forward to making an engaging submissions and or maybe sharing of thoughts. So if you please allow me, I would want to start with making a statement. So I am pursuing my PhD on the subject of the role of logical reasoning in the Indian jurisprudence. So what triggered the idea is that I just want to give a very unstructured introduction before I start with a structured presentation. When there is a question raised in relation to physics, if there is a problem from physics, a question raised to anybody would make them pause for a minute, think, and then say either they know it or they do not know it. there are only two things which they say: I know, I do not know. They don't stand to guess the answer or make a statement in relation to the subject which they do not know. Likewise, similarly, things work for mathematics as well. But what we have noticed very frequently is that everybody has got an opinion on how a particular judge should have ordered, or such a particular advocate would have proceeded with the case, or in most often used language, whether this is justice or injustice. If we get back to the foundational principles, we get to see that if there is a problem arising from physics, there is a resolution coming within the subject. And if there is a question in mathematics, the resolution also lies in mathematics and not in English grammar. If that is the case with all the other subjects, why not it be the case with law? Because most of the time, when we have a legal problem, people give an answer which resonates logic, not law. I would want to argue today before you. I may be wrong, I may be right, or I am not aware. But I would want to just share my thoughts that law is also more concrete and axiomatic like geometry and not experimental like science, where logic can be implemented. This is my hypothesis and this is the argument which I want to put forth. So before that, sir, just to make the session a little interactive, what I want to put to the audience or put to my friends, colleagues, seniors, juniors, everybody is, if you were to see a smoke and I ask you a question, what is the weight of the smoke? I would not get an answer immediately because people would want to stop, pause, think, and then maybe come up with an answer. Likewise, if I ask somebody, please divide 30 with half and add 10 to it, what would be the answer? They would want to pause, think. 30 divided by half. Okay. So I need to put 30, then divide it by half. That is equal to 60 plus 10.
70.
But there may be other friends who would want to say impulsively or intuitively that 30 divided by half is equal to 15 plus 10 is equal to 25. So there is every possibility that you have a different approach and consequentially you end up at a wrong answer. But that may also look very feasible and very possible also. But that doesn't mean that that's a right answer. So how many right answers can we have for one problem? If that is to be adopted for law, and if there is a problem, what do we call? And what do we call the resolution for it? This is the topic which I intend to present before you all. When we call and ask people about justice or injustice, everybody has an idea about the formulas, the theorems, and the calculative methodology for the other subjects. When it comes to law, I have to pose a question. Sir, again, I just want to have a caution word that whatever I am speaking here has nothing to do with religion, nothing to do with anything else other than law and the legal problems and resolution to be adopted for legal problems. So the question here is, if I were to stop somebody on the road and ask them, what Lord Sri Rama did to Sita was justice or injustice? People would have a quick answer to say either it is justice or injustice. But my only question to them is, how did you derive at this? How did you derive whether it is justice? How did you derive whether it is injustice? There is no fast laid rule for this. They say that's how. And they start narrating a series of facts. But are the facts going to decide? Are the facts only element which are going to decide or conclude a legal problem? Is that we want to discuss today, and also say that when it comes to resolution or finding a resolution to a legal problem, everybody want to put a hand on logic. So reasoning is what is brought primarily to answer a legal problem. So my first question to any student or intern who comes to us is, what is justice in your perspective? How do you understand justice? Because for me to decide whether it is justice or injustice, I need to know the definition of justice or injustice. How do you define justice? Now they pause. Now they start thinking. Now, if you have already answered me that it is injustice, or if you have already answered me it is justice, how did you derive at it? Again, there is a pause. Now recalibrating the entire thought process to understand this. Here I am to explain that a legal problem which is brought to the court and has a proper conclusion which resolves the legal problem is justice. And there may be views which are different from this. I would be glad to take all those views, to collate and maybe make a proper definition for justice. So, how are we going to address the legal problems from law without involving logic is the subject for us today. So, unless we understand the fundamentals of law and fundamentals of logic, where does logic enter into the legal sphere? Where do we use logic in the legal framework? And once I call it axiomatic, do I have to depend on some other subject to be able to substantiate axiomatic nature of law? Because if I am saying it is axiomatic, it is complete. It is proved and established like a geometrical theorem. Then why am I needing logic to explain the axiomatic nature of law? So I come back to start with a famous quotation which says, but I am not using this to validate the existing system. This is only a contribution. So Oliver Wendell Holmes, who is the Chief Justice of Supreme Court of USA, says, the life of law is not logic. It is experience. Now that's where we need to start with. So, law as we read today or we study today is sourced from Shrutis and Smritis. This is what we learn in the law college. And then there is lot of law which we have borrowed from common law principles also. If that is so, then if we say experience, we do not get to see this subject anywhere in the common law principles. Now, where are we deriving this from? When we get to understand the Dharma Sutras and Dharma Shastras, so I place Sutras first and Shastras next, because I need to explain that Sutras are the principles or the propositions, and Shastras are the rules which tell us how to implement these procedural and substantive propositions. Sir, the ancient taxonomies tell us that experience is a collection, or experience is a gathering of intellect. This happens two ways. One, a direct perception, a direct experience, which we call apprehension in English, and anubhava in Sanskrit, which we experience ourselves. And second, a knowledge given by somebody else, or a sharing of knowledge, or seeing things happen to somebody else, and we take it and install it with us, which becomes memory, is smriti. So, the knowledge base is two ways. One, perceiving things by ourselves, and second, having a memory of a particular knowledge. Now, how does this help us? This helps us, or helps the framers of law, to use the experience to make a rationale behind formulation of a particular law. Now, how is logic different from law? Law begins with experience, followed by rationale and the formation of the prescriptions, legal prescriptions. Whereas logic is an inference from the existing. Things are already existing and you infer from them to derive at a particular understanding of things. So this is the fundamental difference between law and logic. So I would just want to give an example of logic. There is a smoke. So the smoke, the mountain, the fire, the Agni, everything is apparent. It is already existing. Nothing was created. But whereas law stands on a different footing, it has to be created based on a rationale. And for logic, we perceive things from the existing and say, if there is a smoke, there has to be fire, or something else which can emit the smoke. If this is an inference already drawn from the existing, this inference is either in the form of deductive inference or an inductive inference. These again lead to analytics. Inductive analysis, deductive analysis. These again result in reasoning. Why should it be like this? Okay, this is a base for construction of argument. Law does not prescribe a mechanism for construction of an argument. Whereas these taxonomies, we have 5 taxonomies which deal with logic. 1, Nyaya, Tarka, Mimamsa, Vaiseshika and Anvikshiki. These 5 have different models of reasoning and they give us the argumentation structure. Now, how is this argument constructed? Nyaya comes first. Nyaya, the first taxonomy says, there are 5 elements which you have to put in place to be able to construct a proper argument. So, how is this constructed? So, what are these 5 elements called? These 5 elements are called avayava. These 5 elements must stand in place, put in place, and take your subject or the facts on hand and try to align them in these 5 elements. And if they align with these 5 elements, you have a constructive argument. And your argument is foolproof. You get through. You win the case. Then, what is done here? I say, this is swavada. There is vada. Vada is an argument. Swavada is when I present my case and when somebody defies this argument and places a counter argument, that's called prativada. And those also have got 5 elements. Again, to defy an argument. So, swords are given to both parties. One, to put all things in one set of 5 elements to make it a concrete argument, and another to the prativadi to defy your argument and show where your argument is wrong because it doesn't fit the formula. It doesn't stand in those 5 elements. Now we need to understand what these 5 elements are. So I just want to quickly see, while ancient structure gives us 5 elements, the modern structure gives us only 2 elements, the premise and the conclusion. Whereas the traditional mechanism says, first bring in the premise, which is called pratigna, a premise, then hetu, reasoning. Reason it. What are you trying to establish? Reason it. And then comes the third one, udaharana, an illustration or an example. Then comes Upanaya. Upanaya is like applying the formula or the rule to the facts on hand, and then the conclusion, which is called nigamana. If all these 5 elements are present and you are able to fit the facts and circumstances of your case into these 5 elements, you have a good argument and a good case to win. For example, I would just want to take the example of a contract. And if there is a legal problem arising out of a contract, then the question, the premise is, what is your right under this contract? You have a vested right which is capable of being enforced, is one point. Second, show it with reason. Show it with a reason or show it with the illustrative mechanism given in the contract. Then comes your upayana. Apply and implement that particular, assuming a breach. Show it as an example how a breach has been conducted, and then conclude sourcing from the premise. There is a lapse if the conclusion straight away flows or depends on the premise, and premise is circularly dependent on the conclusion, which we in our language call the petitio principii doctrine. So there is no independent conclusion, and the conclusion necessarily goes and hinges on the premise for its sustenance, which is called a fallacy. So such an argument would fail. So these constructs are also given what actually is not a good argument. So if the prativadi is able to bring in the points which can defy any of these 5 elements, then it is not a good argument. So what are those 5 and how are they categorized? They are categorized there hetu anvaya. So if we bring in these 5 elements and show that this argument is not sound, the argument fails. There are illustrations and much deeper examples given to this, but I am only conducting or maybe exchanging ideas in relation to the fundamentals of law and logic. So I would now want to go back to law, where I always come up with a legal problem, and legal problem necessarily involves infringement of a right. And again the fundamental question arises, what is a right? And this is where again we pause for a minute and then construct, because we don't do this every day, nor are the students from law school trained on what a right is, because they would say it, I have a right, but they are unable to define as to what a right is. I have a right to be loved by my parents, but if my parents don't love me the way they love my sister, I am not in a position to go to the court and ask for the same amount of love and affection from my parents. Now, I feel I am entitled to that love. But however, if this entitlement is not sanctioned by the statute, and there is no enforceability to this, and there is no protection given by the statute, it doesn't transform or culminate into a right. So, the entitlement which is enforceable in the court of law is right. And then we categorize these rights broadly into 4 segments. I just want to funnelize them. It is in the funnel manner. So I talk about the fundamental ones, which are human rights, globally accepted. And then the second layer, constitutional rights, very specific to each state or each country. And then the civil rights, which are specific to that society, which involve the personal laws, which involve the customary laws, everything which are civic. And then the last and one-to-one right, which is a contractual, a right arising out of a contract. These are the broad classification of rights, which are the reason for a legal problem. So, if we take any problem, it must necessarily arise out of any of these 4 sections. And so, the fundamental principle, ubi jus ibi remedium. If you have a right, you have a remedy. So, this argumentation structure comes into play where I am able to take a premise that I have a right. And then I reason my right with an illustration, an application to the situation on hand, and then conclude why I have a better right over others, if at all they have a right. So how to construct an argument is what comes from the logical subject. But again, drawing a line between these two, I told law is axiomatic. So if it is axiomatic, why are we borrowing the argument structure from logic? There are very wise men who have very categorically stated logic is for lawyers. Why? Because the law, to the extent it relates to the judges, has been imbibed in law at the time of formulation of law. So all these categories, or the doctrines, or the prescriptions, or the principles in relation to fallacy or in relation to structural arguments, interpretations, the aids to interpretation, all of these have been brought into law of interpretation of statutes. So the logic, to the extent it relates or it can be used by law, is already brought into law. So law need not depend or need not borrow ideas from logic or reasoning from logic. So in the process of my inquiry, I have heard many people say law means logic. How would that be? Law is not logic. Law is a prescribed mechanism. So again, we stop at the word law. If somebody wants to say law is logic and law is equal to logic, I want to understand what law is first. So that I can equate or not equate it with law, a logic. So what is law? I tried to get into the statutory prescriptions, study, understand all the documents to say where is the definition for law. Laws are many and they have maybe evolved over a period of time, and the definition must have come in a precedential manner. But do we have a statute which prescribes or defines the word law? If it doesn't, then how do we understand? Because it did not define it. Article 13 of the Constitution keeps it open and says inclusive. It includes rules, regulations, ordinances and many more. But how do I define law to be able to differentiate it with logic? That was the question which has come to me. And I had to sit and formulate a definition. This is where I need all of your help. And to tell me whether I am right or wrong, or partly right and partly wrong, where I need to mend my structure. So this is a formulation that I have made. I took the word sutra from Dharma Sutras. Sutra also means a thread. Sutra means a principle. So I use this word sutra and say law must be an entanglement, or it is a framework which is a set of principles or a set of sutras intertwined. They have been knitted together. So intertwined, maybe I just want to make a presentation and say intertwined like this. Sutras are a set of principles intertwined to make a framework, a fabric, a legal framework which is used by the sovereign to do two things. One, control, and to conduct the behavior of its subjects and protect the rights of those subjects. This is how I intended to frame. Then arose a question as to there are certain areas where law doesn't operate. Then what operates? Where law doesn't operate? Equity operates. Equitable principles have been brought in to operate. But again, there's a caution word here which I want to say. Where law operates, equity doesn't operate, because equity follows law. That's the maxim. And if equity itself, which is a mechanism or a tool for delivering justice, cannot replace law, where is the question of logic replacing law or logic being equated to law? Equity follows law. So if I may to explain, so I use this board to just quickly explain that where law operates, logic does not operate. Assuming for a minute, illustratively I want to say, law prescribes 6 months imprisonment or 6 months punishment for a particular offense and subject to a maximum of 12 months. I have two zones where law operates. Law says it cannot be less than 6 months. It cannot be more than 12 months. No amount of equity, no amount of reasoning, no amount of logic would help this. Because where law operates, even equity doesn't operate. Then, this element is, this place is the area where equity operates, because a discretion is given to the officer to decide whether this particular offender fits or is, or the offense calls for what kind of punishment, 6 months, 12 months, 8 months, 9 months, whatever. This discretion, today what we call discretion, is equity. Now where is the logic coming? Equity is, it's by the judge. He is exercising his powers conferred upon him by, again, statute. Statute has to confer upon him a discretion and say, this is an area where you can exercise discretion. That's where he derives his authority. No law, no authority. Lowest to the highest courts. When there is no law, there is no authority. So if they are exercising such an authority, it has to be sourced from a statute, be it constitutional law, other statutes, precedents, or other customary law. It has to be sourced from some law to be able to deliver kind of justice. Now again, coming back to the word justice, we said it is a legal problem which should have a proper solution. Not all keys open the locks. The right key opens the lock. Now how do we identify this right key to that right problem? This our ancient taxonomies have very well explained that. Please look at 3 principles to be able to understand whether this conclusion is a right conclusion or not. Please check if you have a problem and a solution has been given, is it leaving a residue? If it leaves a residue, it is not a proper conclusion. Second, if that aggravates the problem, you took a problem to the court or you took a problem to somebody for a resolution, and when the mechanism of resolution was implemented, the problem got aggravated. This is not a right solution. Third, this problem gets subsided, but a new problem crops up. I'll quickly give you an example of a tummy ache. I go to the doctor with a tummy ache. He gives me a medicine. 80% of it has come down, but then I still carry the 20% problem. So, the solution wasn't complete. It's not a right conclusion. Second, I go to him and then, apart from not getting any relief from the stomach ache, I have a skin allergy from the medicines I have taken. That has aggravated my problem. And third, I use these medicines. A very classic example is steroids. I use this medicine. My stomach ache has come down. But then, I have joint pains now. Severe joint ache or some other problem, chronic problem, which I am unable to deal with. So this actually is what I intend to say when I say right conclusion to a problem. And law is the only subject which tells you how a right solution has to be brought for a legal problem. So let us not look for solutions from logic and other subjects to resolve our legal problems. So we are equipped completely under statute to be able to address our legal problems. So with this I intend to conclude on the fundamentals of law and logic.
It's over, you are continuing.
No, sir. Unless somebody has a question to ask.
Thank you very much, Varalakshmi. So nicely you explained so many things, fundamentals of the this thing. How many people are enjoyed this her lecture today? Can you raise your hands?
All the hands. All the hands.
Great.
I can
Please
raise
So much
both
for all this
hands.
love
Yeah.
and affection, sir.
Now I request Ramakrishnan sir, senior advocate barrister, will give a vote of thanks to this. After that, question, answers and other things.
Thank you for the delightful lecture. I enjoyed your combination of Western principles of logic and law with our traditional principles, and you're bringing in together the Nyaya and the 5 branches along with Shrutis and Smritis. It is delightful, especially on a Friday evening when we have spent the morning only on equity, not on law or logic. Thank you.
Very good.
Thank you very much, sir. Karpagam sir, thank you very much. Sridhar Potarazu is also here. Thank you very much, sir. Ramakrishna Veera Raghavan sir and other friends.